Welcome to EB-5 Hot Topics webinar. My name is Joey Barnett. I'm a partner at WR Immigration. Thank you so much for listening. I'm joined by my partner, Vivian, today, who I think is the queen of source of funds. Whenever I have questions about source of funds, I go to Vivian, who is just absolutely incredible and one of the best EB-5 attorneys in the world. And so I'm really, really happy that we get her insight into one of the more complex areas of EB-5, something that is always changing. And we're going to get into what exactly we're seeing. But before we do that, I do want to let you know that we are accepting questions. So if you have those while you're listening in today during the live recording, please put in the chat and we will try to get to them throughout the presentation, or if not, at the end of it. And if you're listening in on YouTube, thank you so much. Please check subscribe so you always get the updated information from WR Immigration. We are a full service immigration law firm, and we are consistently ranked as one of the top EB-5 law firms in the world. And we have offices globally. Our EB-5 practice is primarily handled out of our California office, Southern California office. I'm in Los Angeles, and Vivian's in Irvine. And I do got to say, of course, this doesn't constitute legal advice, but we do want to help. And if you have questions about EB-5 or are looking to file your EB-5 case, please feel free to reach out to us, visalaw@woolstorff.com. Or you can go to our website, woolstorff.com, and you can fill out a form and we'll get in touch with you and schedule a consultation to talk about your EB-5 case. Okay, so let's get into it. Today, we are talking about source of funds. This is one of the most complicated parts to putting together an initial EB-5 petition. One thing that I say to everybody is that no matter what EB-5 project you go with, your source of funds is the same. So get going with an immigration attorney early. Start preparing your source of funds. It can generally take a few weeks or more, depending on how organized and motivated you are and if translations are needed. And get that finalized so that by the time that you're ready to make the investment, you don't have to wait. You can make the investment quickly, file your case, and get your priority date. And what we're going to be talking about today is what we're seeing in adjudication trends, because there's the statute, which was created in 1990, but then changed again in 2022. And they made references to loans in the EB-5 Reform and Integrity Act. Then they have the existing regulatory framework. And then under that, they have the policy manual. All of these things kind of influence how USCIS adjudicates. But then ultimately, what we see and what we look at on a daily basis are these adjudication trends. And the enforcement standards for how they interpret what is in the regs and what is in the statute is changing. And that's why we thought it was so important to have this webinar, is because people need to understand what those changes are. I should also mention that we will be doing other hot topic EB-5 webinars in the next couple of weeks. We're going to be doing one on what the potential gold card may mean to people in EB-5 and how to take advantage of that. We're also going to be talking about doing mandamus lawsuits and how that can get you your conditional green card status through EB-5 quicker than waiting for through an impending backlog. So I'm really excited just to get into it. Overall, we're going to start with something that is more general, and we're going to get more and more complex the deeper we talk about it. But the overall concept with source of funds is, was the invested capital obtained by lawful means? And the government is really, really picky about this. And we're going to kind of talk about what that means from a EB-5 petition preparation point of view. So Vivian, I guess when a client comes to you and says, okay, I want to do EB-5, Like, what is your first step in evaluating a source of funds situation?
Um, for new client, thank you, Joey, for the introduction, by the way. For new clients, I do not go to source of funds in the beginning. Usually, I would just get a general idea of who they are. Because if this person has some background issues or previous immigration history that will be reviewed negatively by the government, he probably won't even be eligible for a green card or EB-5 visa. So I usually just get an idea of who they are, get their resume, get their previous visa applications or whatever, any immigration records, or to understand this person's background and employment, whatever, and then make sure everything's clean. And then we check the source of funds and we go into, what type of money you want to use to fund the 800,000 investment. And is the money going to be from yourself or from someone else, like your family or friend? And then we need to check the background again for the person who's going to provide the source of funds. Because lately we've been seeing some of the most strict USCIS review standards ever, especially around EB-5 source of funds. And some types of source of funds that were previously accepted by the government are now being questioned or even denied. I think that is why we're hosting this webinar at the perfect timing, since a lot of people are filing or trying to file before the visa backlog. So we just want to share what we've been seeing recently on, source of funds. So if you want to understand what documents are you must provide, there is a general list of documents on the USCIS policy manual on the website. But it's just I don't think it helps much because it's very general. It says that you need to provide documents to show that your investment come from a lawful source, and you need to provide documents like business records, financial statements, tax records, property, salary, etc., etc. But in our fees and noise these days, the I think the policy manual has just been ignored, or the review standard has been much, much higher than the list that's being posted on their website. Because the general list says the investor must submit tax returns filed in the past 7 years as applicable. But in practice, the USCIS has been treating this as a strict requirement across the board. They've been asking every investor for 7 years of tax records, regardless of whether this person has used his own money to fund the EB-5 investment. And sometimes they even ask for 7 years tax records for the spouse when the spouse has nothing to do with the EB-5 money. So that is like one big change or trend we have been seeing lately. That is a hardcore requirement on the 7 years tax returns.
What do you I'm thinking about someone who is in the United States on an F1 and doesn't earn any income and hasn't filed any taxes. What do those people who's that money gifted or lent from parents, what do you provide in those situations?
Well, usually we do not provide the person's source of funds evidence if he does not contribute to the EB-5 capital. But these days the USCIS has been issuing what we call a catch-all RFE or NOID, that they will ask for tax records of everyone who's involved in this whole application or founding. Even if for a person or for this student who does not have income and got all the money from parents, they will still ask him to provide any tax records or even K1s, or all the financial records for USCIS. And usually we just explain that these documents are not available because this person does not earn income in the US, but still will receive catch-all RFEs and noise on those issues.
Well, the law says that the investor must provide 7 years of tax returns, and if they're getting money lent or gifted, that the lender or giftor also must provide 7 years of tax returns. And then the regs use this term as applicable. So if it's not really applicable to the source of funds, then arguably it may not be required under the regs. That to me seems like a little bit of a separate requirement than the strict
Yeah.
7
Well, it's
tax
funny.
return.
It's funny that it seems the USCIS is treating this applicable as a separate requirement other than the 7 years tax return. So they're asking for tax returns or financial documents for the time period that's related to the transaction that resulted in the EB-5 investment, plus 7 years most recent tax returns. So it looks like they're treating them as two separate requirements these days.
Exactly my point.
So for
So
example, if you bought a house in 2020, you need to provide your income and tax records before you buy the house. And then you still need to provide tax returns for the most recent 7 years. That's my understanding of the
that's
requirement
my understanding.
today.
That's my
Mhm.
So what happens if you purchase that house in 2015? Then what?
Still, well, it can trace back to 2015, 2005 even. I got a case where the client bought a house in Australia in 2005, and the money was originally from China, and they're asking how this person transferred money out of China in 2005. So that's how far back they can go to ask for the records. But of course, we do not see this type of request in every case, but it did happen in a few cases. And I had cases denied for that reason because the client could not provide historical financial records going back to 20 years. And it's funny that we just refiled the case with the same exact documents, and the second filing got approved with no R fees or noid.
So same facts, different adjudicator, different outcome.
Exactly.
That's very frustrating. I mean, the way that I like to prepare cases is we want to prevent the request for evidence. And so we give them everything. We know what's in their request for evidence. We know they're going to be asking for these things. So we give it to them so that they can check it off their list and approve the case. That's one way of doing it. Other ways of doing it is kind of putting together, I don't want to call it a more like bare bones, but like really just as it relates to these funds and ignoring these other requirements and seeing if an RFE comes back. There's different ways to do it. I like being more proactive and just giving them what they want to see. If I see that a home was purchased in 2015 and they're using that home and the additional equity that they've earned in that home and getting a HELOC and using the proceeds from the HELOC to fund a portion of the EB-5, yes, I want to know and see how you earn money from 2012, 13, 14, and 15, and how you specifically earn the money for the down payment on the home that you're now using as collateral for the HELOC. So it really does go back and back. I need people to really understand that it's not just a 1 to 2 week thing. You may think that you have documents ready, but once you get going with an experienced immigration attorney, this can take a couple of months, even in some circumstances. If you don't have documents, then it may not be the best source for EB-5, or you have to think of alternatives. For example, another thing that comes up is like ancestral land in India. Well, this was land that my mother wants to sell. She was given it from her grandfather or from her father. Well, how did grandfather earn the land? Oh, well, he's had that in the family for a long time. What evidence can you use to show that they've had this? Are there title deeds? How did the grandfather earn the money to purchase the land that is now being used to fund your EB-5? They really do get super picky on those things. I always like to use the term forensic accountant. They want to match debits with credits, right? So when we talk about, and that's sort of the next slide here, is this traceable path. It's not enough to say, yeah, I earned a certain amount of money based on my employment income, and I'm using this money, and I'm using this other money for EB-5. They want to see specifically that there's a traceable path from the money that you specifically earned and the money that is being invested. Okay, so it's not about your net worth. It's not about the money that is not being transferred to the NCE. It is specifically about the money that is coming in. And one of the things that we always talk about is commingling. Vivian, can you like just give us a little breakdown on like what commingling is and why we like to avoid it?
Yes. So to trace the EB-5 path of funds, the USCIS will usually require continuous bank statements. So if they see, the money was taken out from the bank account and later put it back in, they want to see where the money went. For example, we've seen a few cases where the applicant sold a property to fund the EB-5 investment, but instead of wiring the money directly to the NCE, they loaned it to a friend. And only after the friend repaid the money, then they wired the money to the NCE. So there's a break in the path. And now the USCIS will treat the repayment from the friend as a brand new source of funds and asking the friend for documents to show where the loan repayment came from. So this is the same issue with the currency exchange, right? If an applicant exchange a local currency with a friend or a currency exchange company for equivalent amount of US dollars, the USCIS will treat those US dollars as coming from a new source. And whoever provides the US dollars will have to document the source, including providing, 7 years tax return, financial bank records, and everything.
Yeah, that's a great point. There's a question that someone put up. It's like, well, can we get an unsecured loan from friends and family? Is there anything in the law that is preventing someone from doing that and from using that for EB-5?
No.
No,
No,
the answer
you
is
can get
no.
you can get a loan from a friend.
You can get a loan from a friend. You can get a loan from a company. You can get a loan from a bank. You can get a loan using your home as as collateral. You can get a loan using securities that you own as collateral. You can get a loan from a private company. For a while, there were these regional center affiliate loans, which we're going to talk about later, that you could have also used for an EB-5 investment. Those, for the most part, except for that last one, those are all permissible. The question becomes, how did you either earn the money that is being used to purchase the asset that is being used as collateral for that loan, or if it's being lent from a family or a friend or that company, how did those individuals lawfully obtain that money that is now being lent to you? So yes, you can use those. And I have used those. There was the big Zong decision. That was the DC court decision, and it's a circuit court decision that came out of the DC jurisdiction maybe 5-6 years ago. They pretty much were saying that no, loans do not have to be secured in order to count as cash into an investment for the NCE. The EB-5 Reform and Integrity Act also pretty much said that loans are permissible as long as you're not trying to skirt around restrictions on the use on source of funds. I don't see that happening here. If you're getting money gifted from a family member, I don't see any restriction on source of funds that is being skirted. It's just you're getting a gift from a family member or you're getting a gift from a friend. I have a number of clients who've gotten their EB-5 cases. They're on H-1B. They're using money from RSUs. Maybe they're getting a 401k loan. Maybe they're using some accumulated salary income, and then their friend is giving them the final $50,000. Okay, that's no problem. Great friend. They're lending it to them. Show me how the friend earned that money. Now, the question then becomes are they going to ask about how that money was repaid, how that loan was repaid? My argument is that is not requirement. I have not seen USCIS ask about that. To me, I think it's frankly unlawful for them to ask about it, because the only thing that you need to show that was lawfully obtained capital is the money that was invested in the NCE, not how you earn the money that you use to repay the loan. So I haven't seen them ask that yet, but we're going to be talking about how you can sort of make sure that these are good faith loans, right? They can't be sort of loans that skirt around the rules that are associated with a normal loan agreement. And we're going to get into that. Do we have to share? Here's another good question. Do we have to show all the mortgage payments if we take a HELOC loan, or is it only the source for buying the property? When I put cases together, generally I have only done it for the down payment. I have not seen USCIS ask for evidence on how the mortgage payments were made, because we also include the W-2s and tax returns, and we show that they make enough money. And I think USCIS just presumes that it's coming from the W-2 income. I haven't seen them ask for that. Here's a good question. Use source of funds used to purchase the home in HELOC. What about relying on these new EB-5 cases that say you don't need a full trace? Okay, that's a great question. Those are district court cases that have no precedential value. I'm not trying to get into a fight. I'm trying to get in a case approved. So I'm not following the arguments that are there as a backup when I am preparing a case, because I am expecting USCIS to push back, and I don't want to fight. I want an approval. I don't know, Vivian, how are you treating it the same way?
Yeah, I don't think it makes sense. So, well, that's what the source of fund law is meant for, right? You need to document the source. If you don't need to show the source of purchase in the home, then there shouldn't be any source of funds requirement. Then,
Right. I think those are great cases, and they're super helpful, and we use them in RFEs or NOID responses or in MTRs and things like that. But if I'm trying to get a case approved, I'm not relying on them.